Under warrantless searches, when the right is voluntarily waived, for a valid waiver of a constitutional right, it must appear first that the right exists. Secondly, that the person involved had knowledge, either actual or constructive, of the existence of such right. And thirdly, that the said person had an actual intention to relinquish the right. D. Garcia versus Loxin, 65 Field 689. The consent must be voluntary, that is, unequivocal, specific, and intelligently given, uncontaminated by any duress or coercion. Hence, consent to a search is not to be lightly inferred, but must be shown by clear and convincing evidence. Whether consent to a search was in fact voluntary is a question of fact to be determined by the totality of the circumstances, the age of the defendant, whether he was in public or secluded location, whether he objected to the search or passively looked on, the education and intelligence of the defendant, the presence of coercive police procedure, the defendant's belief that no incriminating evidence will be found, the nature of police questioning, the environment in which the questioning took place, and the possible vulnerable subjective state of the person consenting. It is the state that has the burden of proving by clear and convincing evidence that the necessary consent was obtained and that it was voluntarily and freely given. Caballes versus Court of Appeals, GR number 136292. Some cases showing valid waiver in People versus Umawing, GR number 99050, September 2, 1992. The accused driving a vehicle was stopped at a checkpoint, and when the vehicle was inspected, the soldiers asked permission to see the contents of a bag which was partially covered by a spare tire. The accused consented, and upon inspection, the bag was found to contain marijuana. In People versus La Serna, GR number 109250, September 5, 1997, the occupants of the taxi cab readily consented when the policeman sought permission to search the vehicle. In People versus Exela, GR 76005, the right was deemed waived because the accused did not object to the admissibility of the evidence during the trial, and the submissive stance after the discovery of the bag and the absence of any protest, which thus confirmed their acquiescence. Searches of passengers at airports. Section 9 RA 6235 provides every ticket issued to a passenger by the airline or air carrier concerned shall contain among others the following condition printed thereon. Holder hereof and his hand-carried luggages are subject to search for and seizure of prohibited materials or substances. Holders refusing to be searched shall not be allowed to board the aircraft, which shall constitute a part of the contract between the passenger and the air carrier. In the case of People versus Catward, GR 119772, it was held that when the accused checked in his luggage as a passenger of a plane, he agreed to the inspection of his luggage in accordance with customs laws and regulations, and thus waived any objection to the warrantless search. In People versus Susan Canton, GR 148825, it was held that a search made pursuant to routine airport security procedure is allowed under RA 6235, which provides that every airline ticket shall contain a condition that hand-carried luggage, etc., shall be subject to search, and this condition shall form part of the contract between the passenger and the air carrier. To limit the action of the airport security personnel to simply refusing the passenger entry into the aircraft and sending her home, as suggested by the appellant, and thereby depriving the security personnel of the ability and facility to act accordingly, including to further search without warrant, in light of such circumstances, would be to sanction impotence and ineffectiveness in law enforcement, to the detriment of society. Thus, in this case, The strip search in the latest room was justified under the circumstances. But in People v. Barros, GR 90640, March 29, 1994, the silence of the accused was not construed as consent. Rather, it was a demonstration of regard for the supremacy of the law. In this case, the warrantless search was declared invalid because there was no showing of any circumstance which constituted probable cause for the peace officer to search the carton. Neither did the peace officers receive any information or tip-off from an informer, nor did they contend that they detected the odor of dried marijuana. In Anyang v. Kamalek, GR 104961, the Supreme Court said that in the face of 14 armed policemen conducting the operation, driver Aureliano, being alone and a mere employee of the petitioner, could not have marshaled the strength and the courage to protest against the extensive search conducted on the vehicle. Consent given under intimidating or coercive circumstances is not consent within the purview of the constitutional guarantee. And in People v. Tud, the Supreme Court said that acquiescence in the loss of fundamental rights is not to be presumed. The fact that a person failed to object to a search does not amount to permission thereto. In any case, any presumption in favor of regularity would be severely diminished by the allegations of appellants that the arresting officers pointed a gun at them before asking them to open the subject box. Appellants' implied acquiescence, if at all, could not have been more than mere passive conformity given under coercive or intimidating circumstances, and thus is considered no consent at all within the purview of the constitutional guarantee. Consequently, appellant's lack of objection to the search and seizure is not tantamount to a waiver of his constitutional right, or a voluntary submission to the warrantless search and seizure. When there is valid reason to stop and frisk. Stop and frisk searches are necessary for law enforcement, that is, law enforcers should be given the legal arsenal to prevent the commission of offenses. However, this should be balanced with the need to protect the privacy of citizens. The balance lies in the concept of suspiciousness present in the situation where the police officer finds himself. A basic criterion would be the police officer, with his or her personal knowledge, must observe the facts leading to the suspicion of an illicit act. It is the police officer who should observe facts that would lead to a reasonable degree of suspicion of a person. The police officer should not adopt the suspicion initiated by another person. This is necessary to justify that the person suspected be stopped and reasonably searched. Anything less than this would be an infringement upon one's basic right to security of one's persons and effects. People v. Victor Kogaed, GR 2003-34, July 30, 2014. Stop and frisk is also called Terry searches. And if you heard the first part of this audio, this is the continuation of the case of Terry versus Ohio, 392 U.S. 1. In the middle of the afternoon of October 31st, 1963, veteran police officer Martin McFadden was in his usual beat in downtown Cleveland, a place he had covered for 30 years as member of the Cleveland Police Force. McFadden saw two unknown men who later were identified as Terry and Shelton, and who by their acts appeared to him to be engaged in an elaborate yet casual reconnaissance of a store. At one point, a third man, later on identified as Katz, came to confer with the first two, then disappeared and then rejoined the other two. Suspecting them to be armed and fearing that the three were preparing to rob the store, McFadden approached the men, identified himself a police officer, and asked them to identify themselves. When they simply mumbled an answer and did not get a clear and audible response, he patted down the outer garment of Terry and felt a gun in his pocket and removed the same. A gun was also recovered from Shelton. Terry was subsequently convicted for carrying a concealed weapon. The Ohio Court of Appeals affirmed the conviction, and the Ohio Supreme Court declined to hear the case, claiming that no substantial constitutional question was involved. The U.S. Supreme Court then took cognizance of the case. In the Supreme Court, Terry contended that there exists no probable cause for his arrest, that since the stop was an arrest and that the frisk was a search under America's Fourth Amendment, freedom from unreasonable searches and seizures, probable cause is required. The argument was rejected by the Supreme Court. The court held that the acts of Officer McFadden were acts which a reasonably prudent man would have done in believing that Terry was armed and that he presented a threat to the officer's safety while he was investigating his suspicious behavior. The actions of Terry and Shelton were consistent with McFadden's hypothesis that these men were contemplating a daylight robbery, which reasonably would have been carried out with a deadly weapon. Nothing in their conduct from the time he first noticed them until the time he confronted them and identified himself a police officer gave him sufficient reason to negate that hypothesis. Mumbling an unclear response to the officer's distinct question did nothing to clear up the suspicion. The record observed the court evidences the tempered act of a policeman who, in the course of an investigation, had to make a quick decision as to how to protect himself and others from possible danger, and he took limited steps to do so. The court likewise noted that Officer McFadden's actions were not invasive and overly intrusive. He patted down the outer clothing of Terry and his two companions. He did not place his hands in their pockets or under the outer surface of their garments until he had felt weapons, and then he merely reached for and removed the guns. He never did invade Cat's person beyond the outer surfaces of his clothes, since he discovered nothing in his pat down which might have been a weapon. Officer McFadden confirmed his search strictly to what was minimally necessary to learn whether the men were armed and to disarm them once he discovered the weapons. He did not conduct a general exploratory search for whatever evidence of criminal activity he might find. The court concluded that the revolver seized from Terry was properly admitted in evidence against him. At the time he seized Petitioner and searched him for weapons, Officer McFadden had reasonable grounds to believe that Petitioner was armed and dangerous, and it was necessary for the protection of himself and others to take swift measures to discover the true facts and neutralize the threat of harm if it materialized. The policeman carefully restricted his search to what was appropriate to the discovery of the particular items which he sought. The court held that where a police officer observes unusual conduct, which leads him reasonably to conclude in the light of his experience that criminal activity may be afoot, and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled, for the protection of himself and others in the area, to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Such a search is a reasonable search, and any weapon seized may properly be introduced in evidence against the person from whom they were taken. Summary of the Terry Doctrine. A reading of numerous jurisprudence discloses that The stop and frisk principle serves a dual purpose: the general interest of effective crime prevention and detection, and two, the safety of the police officer to take steps to assure himself that the person with whom he deals with is not armed with a deadly weapon that could be used against him. The Terry doctrine is of two parts: the stop and the frisk. A valid stop by an officer requires that he has a reasonable and articulable belief that criminal activity has happened or is about to happen. The frisk, made after the stop, must be done because of a reasonable belief that the person stopped is in possession of a weapon that will pose a danger to the officer and others. The frisk must be a mere pat down outside the person's outer garment and not unreasonably intrusive. The gist of the ruling in Terry considered as constitutionally permissible a stop and frisk despite the lack of a probable cause to make a full-scale arrest. While conceding that the search was a search as defined by the Constitution, it did not agree with the accused that the constitutional prohibition on unreasonable searches and seizures was violated when he was stopped and frisked without a probable cause. The test of the conduct of an officer under similar circumstances was not the existence of probable cause, because no full arrest is made, but it cannot be mere suspicion. It has to be a genuine reason, according to the Philippine decision. Because of the important interest in protecting the safety of police officers, the court held that a law enforcement officer has the authority to stop someone and do a quick surface search of their outer clothing for weapons. This is allowed if the officer has a reasonable belief based on a genuine reason, and in the light of the officer's experience and the surrounding circumstances that a crime has either taken place or is about to take place, and the person to be stopped is armed and dangerous. This reasonable suspicion must be based on specific and articulable facts, and not merely upon the officer's bare suspicion or hunch. Terry emphasized that a reasonable belief for making a stop may also be followed by a frisk, which is equally reasonable, which means it should not be broader than is necessary to find weapons in the person briefly stopped. The ruling that probable cause is not required in a stop and frisk situation is Terry's significant contribution to jurisprudence. Terry versus Ohio did not justify every stop. Before an officer stops a private citizen in the street, the act must be justified by a concrete facts pointing at the least towards a possible criminal activity where no crime is still apparent to the officer. Terry calls these concrete facts as the specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. A mere deep suspicion by an experienced officer that criminal activity could take place is not sufficient for the application of the Terry doctrine. He must support his conclusion by particularizing the acts that led to his conclusion. This principle of stop and frisk search was not applied by the court in the case of People versus Kugayed. In this case, a police officer received a text message from an informer that the accused would be transporting marijuana. He ordered the setting up of a checkpoint to intercept the accused, who was in a passenger jeepney. Upon reaching the checkpoint, the driver of the jeepney disembarked and signaled to the officer that he had two passengers transporting marijuana. The accused, one of the persons pointed to, was asked to open his bag, which revealed bricks of marijuana. He was arrested and charged for a violation of the Comprehensive Drugs Law of 2002. Is the search justified under the stop and frisk doctrine? The Supreme Court emphatically rejected the application of the stop and frisk doctrine because there was no compliance with the genuine reason requirement, which should emanate from the officer's own observation and assessment of the facts. In the case of the accused, the officer merely adopted the suspicion of another person, the driver, The court observed that there was nothing suspicious, moreover, criminal about riding a jeepney or carrying a bag. The assessment of suspicion was not made by the police officer, but by the jeepney driver. It was the driver who signaled to the police that the accused was acting suspiciously and that two of his passengers were carrying marijuana. Had the jeepney driver not pointed to the accused, he would not have been identified by the police officer. People v. Kogay, GR 2003-34. Canine or dog sniff test, asked in Bar 2014. Does the sniff of a trained drug detection dog constitute a search requiring the prior issuance of a search warrant, supported by probable cause? On various occasions, the question was addressed by cases decided by the Supreme Court of the United States. The canine sniff test was applied by the court differently depending on the place where the sniff was done, as when the same was conducted in a private residence, airport, highway, or in a routine traffic stops. Florida v. Jardines, March 26, 2013, in a case decided by the United States Supreme Court, which held that the employment by the police of a trained drug detection dog to sniff for narcotics on the front porch of a private home, in the absence of consent of the homeowner, requires a search warrant, the dog sniff being a search within the meaning of the Fourth Amendment to the United States Constitution. The case had its inception from a tip received by the police from an anonymous informant claiming that the residence of the respondent, Jardines, was being used to grow marijuana. Acting on the information, a detective had a police dog handler take a trained drug detention dog up to the front door of the house of the respondent. When the dog indicated that the house was positive for the odor of narcotics, the detective went up to the front door and personally smelled the odor of marijuana. He then applied for a search warrant, which was issued. The subsequent search conducted by virtue of the warrant confirmed that marijuana was being grown inside the house, and the accused was arrested and charged. In the trial court, the accused successfully moved to suppress the evidence obtained by the police. However, a contrary ruling was made by a Florida appellate court, which ruled that a canine sniff is not a Fourth Amendment search. Jardines was, however, sustained in a subsequent review of the order of the appellate court by the Florida Supreme Court. It did not support the argument of the prosecution that the use of a canine sniff under the circumstances was an acceptable warrantless search. The Supreme Court of Florida, in effect, agreed with the trial court's decision to suppress the evidence, holding that the officers had engaged in a Fourth Amendment search unsupported by probable cause, thus rendering invalid the warrant based upon information gathered in that search. On March 26, 2013, by a 5-4 margin, the Supreme Court of the United States affirmed the Florida Supreme Court. It held that the government's use of trained police dogs to investigate the home and its surroundings is a search within the meaning of the Fourth Amendment. In the ruling for Jardines, the court made some significant pronouncements summarized as follows. The Fourth Amendment, which protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, establishes a simple baseline. When the government obtains information by physically intruding on persons, houses, papers, or effects, a search within the original meaning of the Fourth Amendment has undoubtedly occurred. B. The officers gathered information in an area belonging to Jardines and immediately surrounding his house, and which enjoys protection as part of the home itself. They gathered the information by physically entering and occupying the area to engage in conduct not explicitly or implicitly permitted by the homeowner. That the officers learned what they learned only by physically intruding on Jardines' property to gather evidence is enough to establish that a search occurred. C. The Fourth Amendment does not prevent all investigations conducted on private property, as when an officer gathers information in open fields, even if those fields are privately owned, because such fields are not enumerated in the amendment's text. But when it comes to the Fourth Amendment, the home is first among equals. At the amendment's very core stands the right of a man to retreat into his own home and there be free from unreasonable governmental intrusion. This right would be of little practical value if the state's agents could stand in a home's porch or side garden and troll for evidence with impunity. The right to retreat would be significantly diminished if the police could enter a man's property to observe his repose from outside the front window. The area immediately surrounding and associated with the home, called the curtilage, is part of the home itself for Fourth Amendment purposes. The curtilage is intimately linked to the home, both physically and psychologically, and is where privacy expectations are most heightened. Oh, and before I continue, let's take a quick break and take the time to make sure you are subscribed. Also, please let those ads play, even if it's not at all entertaining. It's helping me monetarily. I so appreciate it. Thanks. A license to enter the curtilage of a home may be implied from the habits of the country. This implicit license typically permits the visitor to approach the home by the front patch, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Thus, a police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do. By introducing a trained police dog to explore the area around the home in hopes of discovering incriminating evidence is something else. There is no customary invitation to do that. A dog sniff in an airport was treated differently by the United States Supreme Court from a dog sniff in the front porch of a private home. In United States v. Place, 462 U.S. 696, the court had the occasion to hold that a sniffy by a police dog specially trained to detect the presence of narcotics in an airport is not a search under the meaning of the Fourth Amendment of the United States Constitution. The court reasoned that the sniff of a dog is sui generis, intended to reveal only the presence or absence of narcotics, and thus a warrant is generally not required. In United States v. Place, law enforcement agents retained the luggage of the accused in order to subject the same to a canine sniff test that was performed 90 minutes after the luggage was taken. When the test indicated the presence of drugs, the luggage of the accused was further retained over the weekend in order to obtain a search warrant after a canine sniff detected the presence of narcotics in the bags. After the warrant was obtained and the luggage searched, the agents discovered over a kilogram of cocaine. As to whether or not the sniff test constituted a search, the court explained that a search is an unwarranted intrusion on a person's reasonable expectation of privacy. But the sniff does not require opening the luggage, since it does not involve the exposure of things that do not constitute contraband to the public view. Moreover, the court ruled the sniff merely reveals the presence or absence of narcotics. Thus, it is sui generis and does not constitute a search under the Fourth Amendment. Asked in Bar 2014. However, in this case, even though the agents were not deemed to have made a search of the luggage of the accused, when they subjected it to the dog sniff, their seizure of the luggage was unreasonable because it exceeded the limits of a Terry-type investigative stop. The length of time the agents had possession of Place's luggage was too great, 90 minutes before the dog sniff had been conducted. In City of Indianapolis versus Edmond, 51 U.S. 32, 2000, the Supreme Court was faced with the question of whether or not the police could stop vehicles at checkpoints and subject each vehicle to a canine sniff test around the vehicle's exterior. Significantly, the court refused to recognize the mere general interest in crime control as justification for checkpoints. The court held that because the checkpoint program's primary purpose was indistinguishable from the general interest in crime control, the checkpoints violated the Fourth Amendment. However, as to the validity of a canine sniff test, it ruled that the mere use of narcotics detection dogs to sniff on the exterior of cars does not constitute a search. In Illinois versus Caballus, 543 U.S. 405, a state trooper stopped the accused speeding on an interstate highway. While the trooper was issuing a traffic citation, a drug officer arrived and walked his drug-sniffing dog around the car of the accused. The dog sniffed marijuana as it stopped by the trunk. Inside the trunk, the officers found marijuana. The whole episode lasted less than 10 minutes. The Supreme Court ruled that a warrantless dog sniff of a vehicle is permissible at routine lawful traffic stops where the stop is not unreasonably prolonged. Use of thermal imaging device. In Kilo versus United States, 389 U.S. 347, the United States Supreme Court was confronted with the issue of whether or not the use of a thermal imaging device to determine whether the petitioner is growing marijuana inside his house is a search and thus required a warrant. Agents suspected that marijuana was being grown inside the home of the petitioner. The law enforcement officers used a thermal imaging device to scan the home to determine if the amount of heat emanating from it was consistent with the high-intensity lamps typically used for indoor marijuana growth. The scan showed that there was unusual heat in one part of the house when compared to the other parts of the same house. Based on the thermal imaging, a search warrant was applied for and issued to search the home of the petitioner. The officers found marijuana being grown indoors. The petitioner was indicted on a federal drug charge. In the lower courts, he unsuccessfully moved to suppress the evidence seized from his home. The court, however, disposed of the issue by holding that where the government uses a device that is not in general public use to explore details of a private home that would previously have been unknowable without physical intrusion, the surveillance is a Fourth Amendment search and is presumptively unreasonable without a warrant. What is the effect of an illegal search and seizure, fruit of the poisonous tree doctrine? 2005. The effect of an illegal search and seizure is expressed in the following constitutional provision. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. If the evidence is obtained through an unlawful search, the seized item is inadmissible in evidence against the accused. Villanueva versus People, GR 199042. A search warrant illegally obtained or secured, or which is issued in violation of the Constitution or the rules, may be quashed through the proper motion, as in a motion to quash the search warrant, as in the 2012 bar. Also, when evidence is illegally obtained, a motion to suppress the evidence is in order. The general rule is that all searches and seizures made without a warrant are invalid. The illegality of a search and seizure occurs not only from the failure to obtain a warrant when required, but also from the failure to comply with the procedures for obtaining a warrant and in the execution of the same. Such failure will result in the application of the exclusionary rule. The exclusionary rule prevents upon proper motion or objection the admission of evidence illegally obtained. Thus, the most important fact of an illegal search and seizure is the exclusion of the evidence obtained from being used against the person whose rights were violated by the search, the evidence being the proverbial and jurisprudential fruit of the poisonous tree. Asked in the 2005 bar, the violation of an individual's rights also inevitably results into civil, criminal, and administrative charges against the officer responsible for the violation. The prior rule embodied in Moncado v. Peoples Court 80 Phil 1 held that the unconstitutionality of the searches and seizures does not affect the admissibility of the evidence obtained, because the criminal should not be allowed to go free because the constable has blundered. The non-exclusionary rule in Moncado was anchored on the theory that the citizen is protected by other provisions of the laws and as means of redress other than the exclusion of evidence unlawfully obtained, such as actions or damages against the erring officers and the person who procured the warrant. This theory, however, was subsequently rejected in Stonehill v. Diokno, 20 Scra 383. As Stonehill declared, non-exclusionary rule is contrary not only to the letter but also to the spirit of the constitutional injunction against unreasonable searches and seizures. We hold, therefore, that the doctrine adopted in the Moncado case must be, as it is hereby, abandoned. What is the sanction? The proceedings under Rule 126 of the Rules of Court do not provide for the filing of counterclaims for damages against those who may have improperly sought the issuance of the search warrant. However, these aggrieved have the right to seek damages if the circumstances warranted by separate civil action for the wrong inflicted on them by an improperly obtained or enforced search warrant. Del Rosario versus Duanto Jr. et al. DR 180-595. March 5, 2010. There is civil liability based on the concept of an independent civil action for violation of a person's right to be secure in his person, house, papers, and effects against unreasonable searches and seizures. Under Article 32, Number 9 of the Civil Code of the Philippines, this liability is separate and distinct from any criminal liability that may arise from the revised penal code, like A. Violation of domicile, Article 128 Revised Penal Code, or B. Search warrant maliciously obtained and abused in the service of those legally obtained, Article 129 Revised Penal Code, or possibly C. Searching domicile without witnesses, Article 130 of the Revised Penal Code.